Hi, my name is Jocelyn King. I'm the CEO and founder of VirgilHR, and I'm here in beautiful San Diego at SHRM 2025 with Jim Reidy. Jim, welcome.
Thanks so much. Great to be here.
Yeah, we're happy to have you. So you have a really interesting career, and something that I really love to do in the conversations that I have is to figure out, okay, how can we take some of the more complicated issues that are coming up for HR and provide some practical guidance to HR professionals that they can execute in the workplace. So I'm really excited you're here today because your background is fantastic for that. Would you mind sharing with the audience a little more about your career?
Yeah, so I've been a management side lawyer for 36 years. You think that's remarkable because you look so young, but 36 years representing employers from coast to coast. And you think in that period of time, you get pretty much used to things, but really in that period of time, there's been an absolute explosion in workplace laws. You think about it, in HR, prior to 1990, most of the laws that we deal with didn't exist. You had the Civil Rights Act of 1964, amended in 1991, but before that, there was no ADA, there was no ADEA, there was no Older Worker Benefit Protection Act, there was no Family Medical Leave Act, and so on and so on and so on. It seems like all the time there are new laws, and especially state by state, the number of laws, and sometimes city by city, developing new laws and regulations. So it's ever challenging, and I think the other part of it is the workplace is evolving a great deal too. Your parents and grandparents didn't call EEOC or call a lawyer, they just worked. Now there are thankfully, so many outlets for them, but it makes HR more complicated.
Yeah, it absolutely does. The topic is near and dear to my heart because what our company does is we offer employment and labor law compliance software for HR professionals. And it's incredible. We have a team that keeps track of all these laws as they're passed. Really, kind of following the legislation all the way through until it passes. And they are alerting our customers literally on a daily basis.
Sure.
It's interesting to me because we're seeing not just these state laws that are changing at a pretty rapid pace, as you mentioned, city and even county laws as well. And it becomes pretty much impossible for an HR practitioner who works for a multi-state employer to keep up with all of these. Why do you think this explosion has happened?
That's a good question. And so Justice Neil Gorsuch from our Supreme Court actually wrote a book on this fairly recently, within the last year, and it was called Overruled. And it's like, well, what does that mean? And he speaks to the number of laws that our nation has adopted. And is he being critical of that? Not necessarily, but he's saying the breakdown of the family, the breakdown of church, the breakdown of social societies, the nomadic existence of the American workforce where they didn't stay in the same community from cradle to grave and so on, the advent of technology and many challenges. And let's talk about more recently, COVID. COVID caused people to say, life is fragile. Why am I doing this? But on top of that, he says, we have all these laws and regulations that regulate almost every aspect of our lives. Sometimes they outlive their usefulness. And there are a lot of laws on the books that should go away. They're antiquated. The blue laws and otherwise, have those go away. And
what type of laws do you think should go away?
Well, I mean, the blue laws got to no work on Sundays, and things of that nature. And that's not the way it is anymore.
Right.
And there, I mean, you've had an explosion in the legalization of marijuana, by way of example. 43 states have legalized it, either recreational or medicinal or both. There's been a call in Congress to say, can we just finally legalize this and control it somehow? Things like that. But then on the other side, there perhaps are things that, President Bush, the first President Bush, talked about the 1,000 points of light. That was his answer instead of the Family Medical Leave Act. Look, why don't we just have employers have their own policies and procedures? And as long as they don't hit the third rail of violating these laws, let them make these decisions themselves. We've gone as a nation completely the other way, and we've gone into now, and for good reason. Generations ago, pregnant women were discriminated against. There was no allowance for perhaps sick leave or taking time off to care for a family member. That's been addressed. But now it's a very regulated workplace, and what it does is it reduces the flexibility of employers to deal with because they are so regulated, and that's pluses and minuses.
How can that day-to-day work that you're doing as an HR practitioner, how can you keep track of all of these laws and not just keep track of them, but understand some of the laws that might not be easily translatable?
Well, I think companies like yours providing that service, and here at SHRM, there are others as well that do that, or consultants. But I think understanding where you are, meaning do I have employees that work remotely or do I have operations in those states, and what legal requirements come along with having an office there, tax, compliance issues, and so on. But also understanding, can I have a document that says, I know where you're located, say, in this state, but the laws govern here, so our disputes are governed here, and have a workplace-friendly or legally friendly environment. But even then, the interests of those states may trump where you are and say, well, no, we want to protect our residents and so on. So how do you do it? Know where they are, what laws apply, and having some system to basically say, I need to track this stuff, and then communicating that to your C-suite, to the CFO, the CEO, so they understand. When we have people here, this is what that means. Mm-hmm. And when decisions are being made, well, we have to pause here because of this law or that. Mm-hmm. So the burden truly is on HR in that regard, to know what's out there and to comply with it and to deliver the message.
And I do feel like it's a little unfair for HR because they're almost expected to be lawyers. And of course, most of them are not.
Right.
So it does make it a little difficult. Now, you brought up kind of a really interesting point, and that is working with your C-suite. Often it can be quite difficult to get members of your C-suite to get on board with compliance requirements that you have to meet. Do you have any suggestions or advice for our audience on what they can do to try and build that influence and get these members on board with what needs to happen?
Yeah, I think for HR professionals, they need to be in the room with the C-suite. Mm-hmm. And many times they're not. Traditionally, they're not. They can consider to be sort of a subset below. And to me, you need to have a seat at the table. And if you don't, you should ask for one. And if they say no, maybe you ought to look for another organization. But to the extent that you can get the attention of a CEO, a COO, a CFO, and have regular correspondence with him or her, that's critical. Mm-hmm. Because otherwise, the HR, it's the burden of compliance, follow through, and yet they're also accountable when things go south. Having the buy-in from C-suite is critical to a success of an HR professional.
How do you think HR can incentivize a member of a C-suite to take compliance a little more seriously? What type of information could be provided to them?
I think on a regular basis saying, look, this is what EEOC put out with regard to this enforcement action or that. This is what the Department of Labor is putting out here or there. These are the consequences. This is a verdict that came out in an employment case. We really need to be careful at this soft spot or a compliance issue here. So spotting those things and saying, and here are the risks to the organization and financially to our reputation as well for non-compliance. So really, and in many ways you become the typhoid Mary of stress, but I think letting them know, because you don't want to have a situation where the CFO or CEO says, why didn't you tell us? Mm-hmm. Which sadly, that happens a lot.
I know. Yeah. So you'd mentioned to me that there are a couple presentations that you have done or will be doing here at SHRM. Can you talk to me about them?
Yeah. So earlier today, I did a presentation on Is Parting Such Sweet Sorrow? So in other words, quoting Shakespeare in that regard, but dealing with the difficult issues of discharge or discipline in 2025 and how that workplace has evolved and changed, how it's complicated, as you said, and some tips on some basics to more complicated issues on dealing with discipline and discharge. That session went very well. I think I had 900 people there. Wow. It was terrific and great questions throughout. Tomorrow, I'm talking about another bread and butter issue for employers in 2025, and that is what's reasonable today, and that is the interactive process under the Americans with Disabilities Act and the role of HR dealing with employees with mental or physical disabilities and dealing with that accommodation process.
Interesting. So I want to unpack that because both topics are, I think, pretty cool. So on the termination side, you talked about practical tips that you're able to provide to more complicated issues. Do you have an example?
I mean, the practical tips are this. Really, it's pretty straightforward. And it's, I think, elementary to most HR professionals, which is if you're going to hold someone accountable to attendance, performance, conduct issues, they have to know what the rules are. So communicating that. And then for managers and supervisors who are your eyes and ears and potentially your Achilles heel, making sure they communicate to the employees what the expectations are, which comes from the job description, which comes from your handbook, your policies, and otherwise, and then through performance evaluations, where you're falling short, where you could improve, and so on. And being honest and transparent about that. And therefore, when there is a discipline issue, when there is a discharge issue, it's well-founded, and the person shouldn't be surprised.
Yes, I think that's key. If the person's surprised, you haven't done your job
Right.
well. What was, in your opinion, the most interesting question that the audience asked you in that presentation?
Oh, that's a good one. Gosh, because there were so many. One person said, should we hold a pre-termination meeting with someone in advance to tell them, I just want to let you know we're getting ready to terminate you? I've never heard that before. To me, that is a pitcher standing on the mound, looking at the batter and just say, just to be clear, I'm going to throw a fastball right down the middle and it's about 85 miles an hour, just to give you a heads up. Absolutely not necessary. If you've been clear at the outset what the job requires, what our policies are, where you've hit the pitching, no pun intended, where you've met our standards, where you've fallen short of what you need to do or improve, then I don't need to do it. And if you're on a performance improvement plan or you've been warned, I don't need to do a pre-termination meeting. That to me is similar to, honey, I'm going to divorce you next year. So just to give you a heads up.
Yeah, absolutely. You know, it's interesting, like what's going on in the organization, the culture of that organization, or perhaps something going on with that workforce that would influence somebody to ask a question like that. It certainly isn't something that I would have thought of either. And I think it's a great question to ask, you know?
Yeah, perhaps in a union environment that might apply, but otherwise I can't see where it would apply. In fact, she did say that it was her lawyer that suggested it. And I said, I'm sure your lawyer's brilliant. I respectfully disagree.
Interesting. Now, the reasonable accommodations, I think that is something that's quite difficult for HR because so much of it is subjective in
Right.
nature. And especially with mental health in particular, how do you handle, for example, performance issues or even conduct issues that arise from mental health? Any insight you have on that would be really interesting.
Yeah, in that regard, I think a couple of things. One is mental health issues. Thankfully, EEOC has addressed those in recent years, and that's a good thing. But sadly, there's a stigma that attaches to mental health issues. And therefore, just like substance abuse disorders and so on, people lurk in the shadows. They don't want to disclose that they suffer with a mental health illness or challenge of any sort. Accommodating that could be difficult because, again, of the social stigma that attaches with it. And frankly, people don't want to have to deal with those issues. They'll focus instead on your attendance, your performance, and so on. But I boil it down to this with regard to accommodations. David Fram, who used to work with the EEOC, and now he works with an outfit called Nelly, does a lot of training for employers on ADA issues. He really asks a very simple question. What can I do to help? That's it. What can we do to help? Now, it may not be that what you're asking we can do because you focus on the job. And the law says, if you go back to the beginning of the ADA, it was meant to take away physical barriers, curb cuts, wider doors, accessible bathrooms, and so on. And also, give me a fair opportunity as a person with physical or mental challenges. Give me the opportunity to compete for the job. You don't have to create a job for me. You don't have to modify the job so it's not the same job anymore, but give me a fair chance. And the ADA has evolved over the years since 1990, but that's still the basic concept. Can you perform the essential functions of the job with or without a reasonable accommodation? And what is a reasonable accommodation? We're going to talk about it tomorrow, but basically it's what can we do to help as long as it doesn't represent an undue hardship, cost and effect upon the organization, or immediate direct threat to the individual or other people. So the universe is wide open as to what you can do. But ultimately, you spend a lot of time and money recruiting employees, trying to retain them. Let's not have them disposable. To the extent possible, let's see if we can work with that talent and work with an accommodation. So it's an evolving thing. It's difficult for HR, but again, having buy-in of the C-suite is important. Dealing with the bugaboos of notions of every physical or mental disabilities and just saying, look, there are lots of resources available, including the job accommodation network and so on. Let's work with the person to the extent we can. But the person owns it too. They must be able to perform the job as required.
Absolutely. Well, Jim, thank you so much for your time. It was
My pleasure.
incredibly interesting hearing about just your insights on all of this. And I hope that it's something that HR professionals can really unpack and figure out how to provide or how to apply some of the practical guidance that you've provided today.
Yeah, my pleasure.
To their day-to-day work, because this is confusing stuff.
Sure is.
Yeah.
But thanks, and thanks for your outfit and all the things that you folks do. A great resource for employers.
Thank you.